Let's go up to the roof. How's it going? Saturday up here in Quebec, Canada. Thought I'd make a video, a little study break. These are my study breaks, by the way, people. I enjoy these YouTube videos. Definitely doesn't feel like work. But in the interest of exams coming up, I'll talk about something that I'm studying. Right now I'm taking a legal class on the World Trade Organization and all of the international law surrounding it. So why don't I just share some of the basic frameworks under which trade law works. So the World Trade Organization was created in 1994. Its predecessor was called the GATT, the General Agreement on Trade and Tariffs. And obviously it is an organization that favors free trade and sees the benefits as opposed to the drawbacks of free trade. It tries to promote free trade, traditionally through the reduction of trade barriers, tariffs, and duties. But more and more so, especially since the 70s, it's tried to actually change the way that countries regulate internally. And this is actually a very controversial aspect of WTO, because essentially it infringes on the sovereignty of its member states. And sometimes, for certain countries, to a greater extent than other countries, especially if they're new developing world countries that want into the WTO, they have to make concessions to even get in there, and sometimes that makes for unfavorable rules. So I guess the fundamental principle, and actually the first article of the WTO agreement, kind of the principle that defines the agreement, is the most favored nation principle. And essentially it's the idea that if a country is going to give a certain tariff, a favorable tariff on one country for a particular good, it should give that tariff to all other countries. So you can't just give preferential treatment to certain countries without giving it to everybody else. Just a second. It's pretty straightforward. Mostly has to do with tariffs. When a product comes into your territory and you tax it for however much. But there's some issues that run through this, and one of them has to do with classification. Is a cigar the same thing as a cigarette for the purposes of a tariff? And if there are virtually no domestic industries up here in Canada that produce cigars, but there are a lot of industries that produce cigarettes, and say Cuba's industry is heavily dependent on cigars and not cigarettes, if I impose, as a Canadian government, a tariff on all incoming cigars, that is, say, 15% on a pack, and only 5% on cigarettes coming into the country per pack, for the purpose of the WTO, am I discriminating? That gets into the question of whether a cigar is like a cigarette, and there are tests for that. One of the things you can look at is its physical properties. You know, what is actually going on physically that's different between a cigar and a cigarette. Is a cigar fundamentally different, or is it essentially just the same thing as a cigarette with certain flavors and additives added to it? Another thing you have to look at is end uses. You know, are people in the market using cigarettes for the same purposes as they are cigarettes? Another thing is there's actually an organization out there that classifies goods in an official way. And typically this isn't the definitive factor for the WTO, and it gets into issues of international law and how it's really not a cohesive legal system, and there's a lot of debate over whether, you know, an outside agreement in international law, whether the WTO, its dispute settlement body, should be looking at these other legal systems to inform issues that are brought about in front of the WTO's dispute settlement body. You know, should a human rights agreement between two parties be binding in a WTO context if both of the countries are have both ratified the WTO agreement and have both ratified that human rights agreement? Typically, no. There's no crossover, which is different than how law works within countries. Typically, you know, if you had those same types of rules within a country's legal system, they would be used to inform the other, and the court would have to do a balancing act between the two statutes. But there are exceptions. You know, if you're using that other statute to merely inform some kind of definition of a word, it's typically okay. And there are international agreements that are explicitly there for the purposes of interpretation. You know, they guide international dispute mechanisms by giving them rules of interpretation that they should apply regardless of the agreement. So the controversial aspect these days about WTO rules, one of the main things is you know, the extent to which you're signing on to the WTO agreement should bind you to pursue domestic regulatory rules that are in sync with the WTO agreement, and how far the WTO can control a country's choice of regulations. Take, for example, Korea in the 90s imposed a rule saying that imported beef can't be sold in the same stores as domestic beef because, according to Korea, There are stores out there that lie and say that what they're selling is domestic beef, which in Korea um, they say is better than imported beef, and they lie and they essentially say it's domestic beef when it's really imported beef. Sure, that could be the case, but what also could be the case is that the country is using this rule to discriminate against imported beef because it wants to subsidize through this indirect mean its own beef market, and its own cattle ranchers. So to determine that, you have to look at whether the aims, the supposed purpose for which the legislation was introduced, whether it's colorable or not, whether it was actually done for that reason or whether it was done for protection of an industry. And if it's done to protect the domestic industry, it's unfair, and the WTO will say that you can't do that. And it's not clear-cut, because sometimes, even if the goal is legitimate, it has the effect of favoring the domestic economy over an importing economy. So it's really a balancing act between de jure, what is in the statute itself, and how it words the statute, and how does it explicitly discriminate between imported goods and domestic goods. Balance between that, the de jure aspect, actual what's written in the words, and de facto effects of what happens when you put that legislation into effect, and what that means for companies, and the competitive quality of opportunity, market opportunity. Another controversial aspect of the WTO is the fact that it does allow for discriminatory standards, so long as the country is imposing them, is only imposing favorable standards for countries that it has signed a free trade agreement with or a customs union with. The difference between a free trade agreement and a customs union, a free trade agreement, an example of that is NAFTA between the United States, Canada, and Mexico. And an example of a customs union is the European Union. And the difference is merely in that a customs union, every country within that union has to impose the exact same external standards for imported goods. Every country within the union has to impose the same standards vis-a-vis outside parties, whereas a free trade agreement, each party within that agreement can impose whatever standards it wants vis-a-vis others, while everything within that agreement, between the countries within that free trade agreement, has to be the same. So, but there's debates about whether free trade agreements and customs unions really do promote trade, because on the one hand you are opening up trade within that union or agreement, but on the other hand you are imposing discrimination relative for the parties within the agreement to the parties outside of the agreement. And there's a lot of debate as to which goes further in promoting free trade and the reduction of trade barriers. I guess in a nutshell what the argument goes, and I think I'd agree with this, is that free trade agreements are probably, for the meantime, the way to go, just by virtue of the fact that it's so hard to come up with rules that absolutely every single party to the WTO will all agree upon, and in practical, pragmatic terms actually enforce worldwide, globally. It's very hard to come to these agreements, whereas if you allow for a little bit of discrimination and allow for these free trade agreements to come about, you don't have the same burden of creating consensus as you do in the WTO context. Traditionally, the United States has been very much against free trade agreements because it has held this ideal of global equality of market opportunity to be its holy grail. But since the 90s, at least, it's kind of come around and realized that this is kind of an unattainable ideal, and that maybe we should progress through baby steps towards global free trade by implementing these free trade agreements gradually, with the hope that one day every country in the world will be applying the same import standards as every other country. Another thing the WTO allows, and that I think a lot of people who aren't familiar with it don't necessarily know about, is that it does provide for exceptions. If you have a legitimate reason, and there's a list of them, for why you're preventing trade and why you're imposing an unfair tariff or domestic regulation, you won't be punished for this. And some examples have to do with protecting the security of human beings. If you're not allowing for small arms dealings because you want to reduce war in your country, this is seen as an exception. You're allowed to do that, even though it's from a strictly economic perspective, you are imposing discriminatory standards. Other examples have to do with health risks. Canada, or the EU prevented Canada from exporting asbestos in the 90s because it was seen as harmful, a cancer-producing substance. And WTO found that it was the EU was allowed to restrict import of asbestos for this reason. So yeah, there's WTO in a nutshell for you. I didn't cover everything. Not done the class yet, but that's it in a nutshell. 3 years ago, I would have been asking very different questions. I would have been more interested in the validity of capitalism and its market structures, at a fundamental level, and comparing them to communist and socialist ways of doing things. But I guess over the years I've come around to free trade and capitalism, just because the Cold War is over. It does seem that one system has won out over the other, and to still be talking about free trade as an evil, to me, is kind of regressive and swimming against the tide. This is what we've decided on globally, it seems, and we should probably work with it as opposed to against it. I mean, you can get good results through either system if you qualify each system. And it does seem to me that when capitalism went up against communism head to head on a global scale in the Cold War context, that communism was never going to win, probably because a controlled economy is, it requires prediction, and it requires a high degree of coordination. And communism could never have that kind of coordination when there was this outside anarchy constantly, the anarchy being capitalism, and constantly interfering with its capacity to control and predict and decide when and where goods are going to be traded and why. So, if you have any opinions on the WTO, I'd love to hear about them through a video response, ideally, or you can just comment in the comment box below. Thank you for listening. And enjoy the end of fall. And this week, if you are part of a Commonwealth country, remember that Memorial or Remembrance Day is coming up, and to think about your veterans. I'll probably do a video on World War I. I took a class on World War I a couple of years ago, and I'll probably do something to participate in this remembrance coming up. So, until then.